Hello, everyone. On behalf of the faculty of the College of Law, it's my pleasure to welcome you to this year's Canon Memorial Lecture. Please, at this time, take a moment to silence your cellular phones or other mobile devices. The College of Law Canon Lecture Series was established in 1980 as a memorial for Joseph A. Cannon, a Toledo attorney, Lucas County judge, and senior partner at the firm of Cannon, Burns, Mickle, and Geller at the time of his death that year. A substantial gift to the College of Law from his family and friends enables us to attract nationally known experts to UT each year to discuss the American legal system and the social context in which it operates. It is my pleasure to introduce my colleague, Jessica Naus, who will in turn introduce today's Canon lecturer. Professor Naus joined the College of Law in 2007. Before coming to Toledo, she worked as an appellate court attorney for the New York State Supreme Court and as a law clerk for Justice Howard Dana of the Maine Supreme Judicial Court. She earned her LLM from Yale Law School, her JD from Albany Law School, where she graduated #1 out of 216 with a 4.01 GPA, and served as executive editor of the Law Review, and her BA in Latin and English, Phi Beta Kappa from Boston University. At the University of Toledo, she teaches family law, constitutional law, reproductive technology in the law, and sexuality in the law. Without further ado, Professor Naus.
Thank you and welcome. Thank you. Welcome. Thank you all for coming. Professor Asifa Quraishi-Landes is a nationally known expert in Islamic and U.S. constitutional law with a focus on modern Islamic constitutional theory. She teaches in the areas of constitutional law and Islamic law. She's president of the National Association of Muslim Lawyers and serves on the governing board of the Association of American Law Schools section on Islamic law. She's currently working on a book manuscript, Islamic Reconstitutionalism, in which she proposes a new model of Islamic constitutionalism for today's Muslim-majority countries. She is a 2009 Carnegie Scholar and a 2012 Guggenheim Fellow. Previously, she served as a public delegate on the U.S. delegation to the United Nations Commission on the Status of Women, president and board member of Karama, Muslim Women Lawyers for Human Rights, a fellow with the Institute for Social Policy and Understanding, and as an advisor to the Pew Task Force on Religion and Public Life. Professor Quraishi-Landes is a graduate of the University of California, Berkeley, University of California, Davis, Harvard Law School, and Columbia Law School. And so with that, I will turn things over to her for her talk. Excited.
Thank you so much. Sorry? Turn this up a little. Yeah, let's try to twist there. How's that? Good? Yeah, that's better. Yeah, they did say go really close. So yeah, all right. So thank you. I know that there's a lot of competition for your attention today on the television sets, so I appreciate you being here. And I'm very honored to be here. It's really wonderful to be able to talk about this topic with an audience that is interested in the social context kinds of issues that the Canon Lecture is named after, so I'm really honored to be able to contribute. So my topic, as you can see, is Islamic family law in the United States. And this topic of Islamic family law has ended up becoming a central piece of the anti-Sharia movement in the United States. How many here have heard of anti-Sharia legislation happening around different states? Okay, so you're familiar with that phenomenon. Sorry? Sure, you will find out. Good question. So there is a concern about Muslim Americans bringing their religious law into courtrooms in various topics. And so the word that's often translated as Islamic law is Sharia. I will get into that a little bit more detail so you understand a little bit more depth. But the question of what is the role of a state judge in enforcing a family law dispute that involves some issues that involve Sharia or religious law for Muslims has become an issue that is front and center in these anti-Sharia legislation movements. So I'm going to talk about what's actually going on in those courtrooms that are dealing with Muslim family law cases, a little bit about the anti-Sharia legislation itself. There's like a model code that I'm going to put up you can take a look at, and then comment a little bit on what all of that means for what is Sharia for American Muslims, but also what is American secularism today? What are these kinds of questions, and are they addressing them in a really useful way for the future of the United States, where we're moving into being a country where we're multilingual, multi-ethnic, multiracial, multi-religious, and how does that, what do we want to do with that? What do we want to do as American secularism on those topics? So I'm sort of wearing both hats. I teach Islamic law and I teach constitutional law, so I'm interested in this from both sides. So I want to say, first of all, that overall, if you look at all the cases where family law comes up, Muslim family law comes up, it's the courts have neither always automatically rejected a Sharia-based claim, nor have they automatically accepted it, just given it deference. It's much more a complex combination of public policy, general constitutional principles, and the idea of religious accommodation. We have a First Amendment in the Constitution that talks about religious exercise, and so we have 200 years of history of various religious minorities requesting various accommodation for religious practices. So whether it's Catholics, Jews, Mormons, Native Americans, there's a whole host of case law on how do you accommodate for various religious claims. So generally speaking, American law has permitted courts to consider religious law questions to the extent that it doesn't violate American public policy, or if it's not engaging in any kind of doctrinal interpretation of those religions. That would be an Establishment Clause problem where they're interpreting the religion for the public. So in the United States, most often, this is why it was a family law topic here, most often Sharia/Islamic law comes up in American courts in family law cases, usually divorce cases. So that's why this topic is the relevant topic for today. So typically, the issues that come up in these cases are going to be the marriage validity itself, whether the parties were married, and the next question that comes up is whether they were actually divorced. And then there's this thing called the mahr. Now, if you know anything about Jewish law, that might look a little bit familiar because it's actually the same word in halakha or Jewish law. And the mahr is a gift that is given from the groom to the bride and at the time of the wedding. And sometimes the actual payment is deferred to a later date, usually upon the event of divorce. That's a deferred sort of gift. So it gets complicated because that is a financial settlement, right? If it's deferred to divorce, it comes up in all of the different debates over what's the financial arrangement going to be between the two parties. So, so I'll take each of these in a little bit of succession here just to give you a little bit of a summary. So the first one about marriage validity, I wanted to say a little preface here is that we don't really know all the cases that are going on. This is research based on looking at case law that's published, but of course, as you know, if you're a practicing lawyer, a lot of cases don't get published. A lot of the Sharia-based issues often are resolved outside of court, so many lawyers don't even want to get into the Islamic law issues if they end up in the regular state court. So a lot of the religious-based stuff, the debate over Sharia-based claims, are often handled. The couple might go to a local imam, religious authority in the mosque or in the community, and they'll work out a lot of the details that way. The lawyers, sometimes they're Muslim lawyers, sometimes they're not Muslim lawyers handling these cases, often don't really want to bring up too much of these religious stuff in the courtroom because, for one, they're not usually trained in Islamic law. So if it involves a complicated nuance of Islamic law, they're really not equipped to take that up with the court. And then also this anti-Sharia legislation thing that's been happening, there's a little bit of concern that it might throw a wrench into the entire proceedings if they bring it up. So there's often a sense of trying to resolve as much as possible outside of getting into the state court. But nevertheless, there is a sense that state court judges seem to have an appreciation of the combination of religious marriage and civil marriage, or the problem that might happen if you're religiously divorced and not civilly divorced, or the other way around. This idea of this limping marriage or limping divorce with the Jewish community is also dealt with a lot. And state judges have become more aware of that, and they will often say in the proceedings, well, has he given her religious divorce? Something like that, something along those lines where there's an acknowledgement that there's something in there that is not according to the state, but that the state judge is recognizing this is a consideration that the parties might be concerned about. And that's come up more. So marriage validity itself. Is there a marriage? So usually the analysis is whether the marriage if the marriage wherever it was conducted, right? So if it was conducted overseas, there's a matter of comity and what's the arrangements of recognizing a marriage done overseas. if the marriages happen here in the United States, which, by the way, there's many, many more Muslim couples that are born or raised here, and the marriage issues are coming up here. A lot of these cases, when I first started looking at them, most of the couples were married overseas. Now that's not so much the case. So if the parties were married in the States, it kind of depends on the state. Some states have a very strong civil license rule that they'll enforce, and if you didn't get that, they just won't recognize the marriage. Other states have more of a putative marriage kind of arrangement, or sometimes called common law marriage, where they will look at the kind of indicators of how the parties lived and see if they behaved like they were married. Was there a reasonable understanding that they were married in the eyes of the parties themselves and in the public around them? And I want to mention one case about this because it gives an interesting example of one of the themes I'm going to point out today, and that is the complicated situation that American judges are put in when they're trying to understand Sharia/Islamic law, and then really aren't equipped to completely get it completely. And so you end up with these weird cases with some weird conclusions that if you know anything about Islamic law, you're like, where did they get that from? That's not how it's done, or that's not how we think about it. But they're doing their best. It usually involves a lot of expert witnesses and et cetera. So here's this case from 1988 in California called Vryonis versus Vryonis. And this is a case where a couple who had been entered into a marriage here, but there was no written documentation, there were no witnesses. They said they were married by an Islamic process. But it was a unique process within the Shia tradition, which has complicated other additional details that would not necessarily require all these witnesses. So the question is, were they married? All right. So the court looked at, did the wife have a reasonable belief that she was married? And they looked at all kinds of indicators of whether the couple believed they were married. And they concluded, no, they didn't seem to behave in a way that was marriage, so they concluded it wasn't a marriage, so then they didn't adjudicate a divorce. The reason I'm mentioning this case is because the indicators they were looking for are interesting indicators from a Muslim perspective, because the things they looked for are odd from a Muslim perspective. So one of the things they looked for was, did the wife keep her own name? Well, in classical Muslim culture, there isn't a practice of the wives taking their husbands' names when they get married. And it's becoming less and less common today. This is a 1988 case. But it seemed to be an indicator to the court that she didn't think of herself as married. The other thing, even more interesting, is that she maintained a separate bank account. Now, that takes a little bit of interest, knowing something about Islamic law, too. In Islamic law, a woman's property is solely her own property. It is not the property of any man in her life, father, brother, husband, son, anyone. That is hard and fast rule from the very beginning. So it's not a reform idea. So it's very common for Muslim women to keep their assets separate. So the fact that those two were indicators that the couple didn't behave as a married couple was a big red flag to me, that the court wasn't really completely on board with what are the kinds of things that a Muslim couple would be thinking about. Just the disconnect of what are the real indicators. If you're talking about her reasonable belief, those wouldn't be indicators. There might have been other indicators, but not those two. So that's marriage validity. Was there a divorce? These are some interesting cases. So typically, courts look to the divorce, again, standard comity factors. If there was divorce overseas, what are the kinds of provisions we have for recognized divorce overseas, with this added piece, and that is for public policy and due process reasons. They look to make sure that both parties had notice and a hearing and reasonable opportunity to respond. So having said that, I need to give you a little bit of background on all the types of divorce in Islamic law, because one of them, that's no problem. There's going to be a third-party judicial hearing kind of thing. But there's two kinds of divorce in Islamic law that could happen outside of a courtroom procedure. So the three types are, there is talaq, which is probably the word that most Muslims would use when they talk about divorce. And that is the right of a husband to unilaterally divorce the wife without any consent of the wife. She has no say in this whatsoever. There are certain consequences that happen, but for example, if they have a mahr that's been deferred to the time of divorce, he would have to pay that amount. So often women set their mahr quite high if it's a deferred one, in a sort of deterrence to keep him from doing that, right? So it's going to cost you if you're going to just do this out of the blue, right? So that's one kind of divorce. It's unilateral. The wife really, theoretically, in classical Islamic law, there's no hearing. There's no grounds for divorce before a judge or anything. It's just the husband doesn't want to be married anymore. And there's a certain procedural thing he has to do, just verbally, has to go through some certain motions on what happens to make it a divorce. That's the first one, talaq. There's also a third-party divorce that we would be more familiar with, where either party initiates, but clearly it's more relevant for the woman because the husband doesn't need anything to get divorced, really, third party. So the woman's initiating the divorce, and first of all, well, let me say, the first kind is khula, which is if she initiates a divorce and he agrees to it. So if she initiates divorce, he agrees to it. It also can happen completely extrajudicially. It doesn't need to go through a courtroom proceeding. They work out the details of the asset division, which, by the way, if the woman has her assets separate, it's not all that complicated. So maybe some stuff about children, and it's done. So if he agrees to it, that's a khul. So that's also a little bit interesting because there's no judicial proceeding or hearing, and are those going to be recognized? And then the last one, fasakh, is the most obvious one that's similar to us, and that's when there's grounds for divorce. That happens when the woman wants to initiate a divorce and he doesn't agree. Then she needs some state entity to say, I really want a divorce, he's not giving it to me, I can't do this extrajudicial mutual arrangement thing, I want to be divorced. In that case, you would go to a third party, a judge, Muslim judge, and you would establish the grounds for divorce. And depending on the school of law, and I'll talk a little bit more about the schools of Islamic law later, depending on the school of law, that could be really easy or really difficult depending on the facts. All right, so that's the background. So backing up to the American court public policy provisions, if the court is looking at fair hearing and notice and proceedings, you can imagine that the talaq kind of divorces are going to be a little bit difficult to enforce, because what if she didn't have any notice of this ahead of time? Did she have any opportunity to respond? So often talaq divorces will not be recognized if there isn't any kind of proceedings set up. Many Muslim majority countries have set up even judicial proceedings even for talaq. So in some cases, they've already satisfied that. So, for example, in Chaudhry versus Chaudhry, I don't have the year here, I think it was the 90s, there was a divorce by talaq made at the Pakistani consulate in New York. And the court reviewed that and said, well, okay, that we will recognize because in that proceeding, the wife had notice and an opportunity to be heard. So it was conducted according to Pakistani law and the consulate, and the wife had an opportunity to be heard. So they're looking for that hearing and notice factor. Another one, this is 2009, Tarikonda versus Pinjari. The parties were married in India under Islamic law and then moved to Michigan. And then he went to India and got a divorce certificate in India. She then filed for divorce here in Michigan. That's pretty typical, right? If they have any connection to an overseas state, they'll both try to use the law of each of those places. You got lots of choice of law questions. So in that case, the court said the basic rudiments of due process were not followed in the talaq hearing in India, so they were not going to recognize that. So they dealt with the divorce according to Michigan law. So that's pretty typical. They look for some kind of a hearing, due process kind of thing. A couple of cases in more recent history, around the same time, this is 2008, have identified a gender imbalance as part of their analysis in the talaq cases. So in Aleem versus Aleem, this is in Maryland in 2008, the court looks at the idea of talaq itself as it's unilateral that the guy can do it. That seems to be an imbalance in gender, and so the idea of talaq is against public policy, and so it won't be recognized under our due process, equal rights principles in the United States, and so they rejected recognition of the talaq. So that's most of the time what happens with talaq cases. You're probably not going to get much ground if you're trying to enforce a talaq without any kind of notice to the wife and any getting it enforced here in the States. I mentioned the limping marriage situation. What if there isn't a talaq, but they do have the state divorce, right? What happens the other way around? What if the husband didn't issue any divorce and she hasn't done anything, or she hasn't succeeded in getting any religious divorce in their own community and whatever leadership they can get for a religious divorce? I mentioned that some of the state courts seem very sensitive to this dilemma that women are often put in. The Orthodox Jewish community has walked this road ahead of us and have a very similar problem. In Orthodox Judaism, in halakha, the woman in the typical law is, as far as I understand it, is that the husband is the owner of the get, of the divorce. And so even if she wanted to initiate it, she can't get it without his consent. So she really is stuck if he doesn't consent. In Islamic law, there's an avenue for her. It's a lot harder than for him, but at least there's an avenue. So within the Jewish community, the state courts, especially in New York and New Jersey, have been aware of this. And there actually was a law passed in 1979 in New York called the Get Law, which specified that a state court wouldn't grant a divorce until the person wanting the divorce, swears that he or she has taken, quote, all steps solely within his power to remove any religious barriers to divorce. So, religious barriers to remarriage. So, sort of saying, I'm not going to give you your state divorce until you affirm to me that you're not standing in the way of her getting her own divorce within the religious community. And then a second law in 1992 permitted the civil courts to take the status of the religious barrier to remarriage as a factor in identifying the financial settlement. So if he's not giving her this, if he's standing in her way, you can make the spousal payments a little higher or something like that. And that sounds interesting because it does sound like the court is interfering a little bit in the religious practices of this population. And it was challenged and upheld on constitutional grounds that it's not unconstitutional behavior for the state court. So that's New York, though. Not every state has taken that approach. Michigan, there's a Michigan case that's actually really interesting on this, where the husband, this is Hamoud versus Hamoud in 2012, the husband challenged the trial court's use of spousal support as a pressure tool to have him give his wife a talaq. So the court was sort of to do this spousal support pressure, and the husband got upset, and he took it up on appeal. So the trial court had said he hasn't given her, remove barriers to remarriage, and so they gave a modifiable spousal support basically for an indefinite period until he gave her the religious divorce. So it was this higher amount until he gave her the religious divorce, then it would drop down. And he appealed. He said, you can't do that, and he won. So the Michigan Court of Appeals said that kind of pressure from the state court was improper. It was trying to punish one of the parties, trying to pressure into a religious realm. And so in Michigan, the lawyers that I talked to in Michigan were like, yeah, we used to really have the judges help us out on that, but ever since this other case, it's been a little difficult to try to use the state process to get the religious divorce. I want to take a sidestep on that case because I want to talk again about some interesting gymnastics that the court is doing when it's trying to juggle the constitutional and the Islamic law kind of issues. So when I look at that case with my constitutional law hat, I say there's some very interesting constitutional establishment clause questions there. I'm actually really interested in exploring, is that a violation of the establishment clause for state courts to be interfering in religious divorces? That's actually quite interesting, both as the religious minority, but also as just the American secularism, right? But that is not the analysis the court went into. The court instead, it's a very interesting reasoning that again belies their lack of understanding of Islamic law. So here's what the court says. The court says that the trial court's setup of the spousal support order said that basically was giving the plaintiff an incentive to the plaintiff has no incentive to become self-sufficient. She's going to vigorously, she's assured an ongoing income ad infinitum until she gets this divorce. So the idea was she's profiteering from this situation. And that seems very strange to me because the talaq is owned completely by the husband. So what the court was trying to do was get her the talaq. They weren't trying to give her something to hang on forever until he gives her the talaq. Well, that's what she wanted. She wanted the religious divorce. So the thing about the order was if the husband didn't want to get stuck paying this extra money, all he had to do was give her the religious divorce. And under Islamic law, it's totally within his power to do that. She doesn't hold anything over whether or not she gets a talaq. It's all in his hands. So she's not profiteering. All he has to do is stop at any point. I think they're a little confused. I mean, there seemed to have been some I didn't look at the transcript, so I don't know, but it seems that there must have been some expert testimony that was confusing them because there's a line in there where they say, the plaintiff indicated that an agreement existed that would permit her brother and brother-in-law to authorize an Islamic divorce. And then they say, potentially rendering it within the plaintiff's control to prolong her receipt of spousal support. That's super confused. That's okay. So remember the different kinds of divorce, right? One of them is where you need the third party. So her brother and brother-in-law being able to get her this Islamic divorce, they're talking about the one where she's initiating it. They're not talking about the one where he's initiating it, right? So the fact that she can get a divorce without her husband's consent by going to a third party has nothing to do with prohibiting her husband from just giving her a divorce and getting out of the spousal support anyway, right? These are two different kinds of divorce. They're different initiators. So anyway, those are the complications of the divorce cases where I think that there's a basic kind of wrestling with some of these Islamic law questions. Sometimes they get it right, sometimes they get it wrong. And my concern is a lot of these are ending up as precedent in the cases going forward. So I'm going to jump to the mahar because that gets us into a little bit of the current state law, the ban. And that is this. The mahar cases, this is, again, a gift that she gets at the time of the wedding. Often the payment is either at the time of the wedding or at the time of future date, usually divorce. Whether or not the state courts will enforce them has to do with whether the court sees it as a secular contract or not. That's basically what it comes down to. So there's a case in 2002 in New Jersey called Odatala versus Odatala, where the court looked at this and said, okay, I see that he's promised to give her $10,000 upon a certain time. I'm going to look at this as a contract. Let's see if there's a meeting of the minds, if the terms are clear, and as long as it's a secular contract by secular standards, I will enforce it. The court actually said in the opinion, why should a contract for the promise to pay money be less of a contract just because it was entered into at the time of an Islamic marriage ceremony? Clearly, this court can enforce so much of a contract as in not in contravention of established law or public policy. So if the court decides to treat it as a secular contract, it will enforce that payment as a generic contract. And then it really just goes into those kinds of courts, look at, is it vague or not? There's a couple of several cases where the terms really are vague and they're not clear on how much money she would get or what the property division should look like. And so in those cases, they strike it down, but not because there's something wrong with the idea of mahar, but more because I don't understand the terms of this contract, just straight up contract law. So usually I would advise, Muslims, when you are setting up your marriage contracts to just make really sure it's really clear and then hope you're in a state that's treating it like a secular contract and then you'll get your mahar. But everything has changed since the anti-Sharia legislation. So I'm going to put up the language of this model legislation. If you're interested in where these are coming from, the organizations proposing these and pushing them, you can look at American Freedom Law Center, Act for America, ACT, and then their American Law for American Courts, ALAC. All of those locations you can find basically model legislation that most of the states that have been enacting this legislation or proposing legislation will borrow almost exactly word for word from this model that you see up behind me. So, so far, there's been about, I think there's over 200 now, anti-Sharia bills that have been introduced in 42 states since 2010. In 2017 alone, 13 states had anti-Sharia bills proposed, and it's been passed in 20. Among those are Louisiana, Oklahoma, Kansas, Tennessee, Arizona, and others. So this is the language that's often used. Originally, the language said Sharia instead of foreign law. That was struck down as unconstitutional as targeting a particular religion. But now that it says foreign law, it seems to have passed in several cases. So the first time I saw this thing percolating up in the early 2000s, my first reaction was, nah, no big deal. I mean, I already knew these cases. I knew that the courts always looked at public policy anyway. They looked at due process, and they struck it down if the religious claim had something to do with violating public policy. So it seemed redundant to me. And that is until 2012. In 2012, Soleimani versus Soleimani, this is Kansas Superior Court, the court cites the anti-Sharia legislation in Kansas to strike down a woman's mahar request of $650,000. That's not nothing. So here's what happened. So the court identified an earlier case, actually a Michigan case, which did not have an anti-Sharia bill passed in that state at the time. But anyway, they cite an earlier case that had talked about this talaq being something where women didn't have a hearing and therefore it was gendered and so unfair to women. And it cited that to conclude that all of Sharia is gender imbalance, is unfair to women. And so therefore, they wouldn't enforce anything that was coming out of Sharia itself, including giving a woman her mahar. So here's the language. The court says, if the mahar agreement was, quote, the product of a legal system which is obnoxious to equal rights based on gender, a court could not become a proxy to perpetuating such discrimination. And so therefore, based on this, he denied her mahar. That was the claim was coming from Islam, so therefore he couldn't, Islamic law, so therefore he couldn't enforce it. what I want to just comment on this is that the irony of the legislation that this is based on is often the rhetoric that it pushes, that it's there to protect women. It's being legislated to protect women and help women. In fact, Senator Susan Wagley told the Kansas legislature when she was introducing this bill in Kansas that this is, quote, a vote to protect women. And the court, the Kansas court, in that case, in Soleimani case, cited that the fundamental rights that the court was obligated to protect by this bill. So it's ostensibly saying it's going to protect women. But I don't know. I feel like if I talked to Mrs. Odadala and I said, do you feel like this bill protected you by denying you $650,000, I'm not so sure she would agree. So here's the thing about how most secular courts, secular world, in fact, looks at Islamic law, is there seems to be, when I read these cases, there seems to be a presumption that secular law is always better for women. And that whenever it's a concession to the religious law, it's somehow going to harm that principle. And in this case, at least financially speaking, the Islamic law, she would have ended up with more, at least money. And if you add in the point that I made earlier about women's property is always her own property, not owned by anybody, I talked to many women who are frustrated with community property laws when they're in a community property state. Because according to Islamic law, all of their assets would be theirs. But when they move to a community property state, often unknowingly moving to a community property state, when they end up in a divorce, what they thought was their entire house in their name that they had been paying for ends up getting cut in half. By the way, that happened to me. In my divorce, if I had been divorced under Islamic law, I would have ended up with quite a lot more money and assets than I did because it was community property state. So I'm not saying everything in Islamic law is better than secular law. I'm not saying everything, but it's not a one-on-one comparison. You have to look at the particulars. The other thing I want to say is, do we do this with any other law, right? If one aspect of American law is bad for women, do we then decide to deny her Title VII claims, right? I mean, this is like, this one aspect of Islamic law is gendered and biased towards women. I actually am part of a community of scholars who are looking to reform that. But there's other parts of the law that I don't think are gender biased. And in fact, in this case, the mahr is arguably exactly the counterpoint to that unilateral divorce. Because if he unilaterally divorces her, she gets this money. So it's part of the whole package of trying to adapt to the realities of Islamic law that the mahr is a part of. So by taking one part out, but then not really looking at the fact that you're unraveling a whole structure, is really not understanding the nuances of how it actually works. So all of that said, the conclusion here is that for the Sharia ban community, the existing public policy rules is not good enough. They want an absolute ban. The existing system was not enough, and they thought, absolutely, you have to have no recognition. And what I'm seeing when the courts are looking at this is they're really operating more on stereotypes of Muslim women and stereotypes of Islamic law as they're applying this, and less about the nuances. So unfortunately, I'm concerned that this whole movement is it's basically based on two things. One is this fear that Sharia is going to take over American law, constitutional law. I mean, that's a non-starter. That's not going to happen. I teach constitutional law, and I'm constantly assuring everyone, no, we have an establishment clause here. It's not going to happen. The other concern, I think, is actually much more interesting. The other concern of the anti-Sharia movement is that there is something about our American secularism that makes it inappropriate to apply anything that's coming out of religious law. And I think that's actually an interesting question. I'm more interested in looking at, okay, what is the nature of our secularism? That it would actually could or should or how accommodate religious minorities? And in what ways? And is it their family law or is it all their other things? What about inheritance? In general, American law is on the whole pretty libertarian. On the whole, outside of certain activities, you're pretty much left to do as you please, right? There's certain things that are regulated and then the rest of it isn't. And even in family law, even in inheritance, even in things that are so personal, we tend to say, you know what, if you want to get an arbiter or a mediator and you work it out amongst yourselves, you could end up with a divorce arrangement that's not at all what would have happened if you litigated in court, but the courts are more than happy to have it handled off to the side. So it's not a situation, so on the one hand, we have this sense of like, outside of these regulations, do what you want, but also have this very strong strain of equality in this country. Racial, sex equality, all kinds of equality that we kind of want everyone to be treated the same. So these kind of are in contest with each other. But we really don't have a society where we really do treat everybody the same all the time, and sometimes that's a good thing. We have a federal system where you have state law is different across the different states that's tolerated, and we have some federal law that controls that. So we sort of, it's not so much a question of what can we all agree should be the laws for everybody. Really, the way we operate is more like, what are the kinds of things that we're okay with people opting out of, right? What are the kinds of things that we're willing to let states do on their own, whether it's marijuana laws or gambling or whatever? Those kinds of things we let the states do on their own. And there's a lot of things that we allow for religious arbitration and other kinds of arbitration that seem to solve those community problems without much of a threat to the overall system. And I think that as we're moving into a much more pluralistic society, and there's concern about that pluralism. What does that mean if we don't have a dominant Christian denomination as the majority religion in this country? And we don't have a dominant white race in this country? What does that mean as we're going forward? And I think that these cases would be an interesting place to really engage with that question and what should our secularism look like as far as these kinds of religious claims, not just from Muslims, but from lots of others. Other countries have been engaging with this question. There's some issues in England and in Canada I can talk about in the question and answer. But I want to just get to one question about, is this reality of Muslims in family courts, is this a threat to the overall American rule of law? And for that, I do have to go into the what is Sharia a little bit more, because I want to explain a bit more about what do Muslims mean when they're talking about Sharia, because I think that's hugely misrepresented in the media and in people's conversations. So here's a Pew poll. I actually consulted on this Pew poll, so it's kind of painful to put this up because they didn't take all of my advice. So one of my critiques was the way they asked the question about Sharia. It wasn't nuanced enough. So you end up getting this sort of many back Sharia as official law question. Do you want Sharia as official law of the land was the question. And the problem is that when the word Sharia in that question can mean lots of things to different people. So the question really doesn't tease that out. But nevertheless, it's cited all the time by all kinds of public commentators. This poll, this slide, is brought up as, look, see how many Muslims around the world want Sharia to be the government law. And it must then, therefore, mean that Muslims here also want the same thing. So that creates this fear that if you want Sharia in your life, then you also want it governing the law of the land. And that's when the whole concern about, are Muslims going to take over the Constitution with their Sharia, and soon they're going to be cutting off hands for theft and things like that, these like hyperbolic kind of fears that really, when I listen to it, I just get so frustrated because it's missing some fundamental concepts of how Muslims think about Sharia. And it's like I saw it in the cases and I'm seeing it again now. So to unpack that a little bit for you, I want to say part of the problem is we in the West tend to think about law as central with the government, right? That's why I don't like the phrase Sharia law. I hate that phrase because it implies that you're talking about the government. So when we say law in the United States, just think about the word yourself. You're kind of thinking what the government makes me do or prohibits me from doing or rewards me with taxes for doing. It's all about the state. When there's any other kind of rules that we govern our lives by, we tend to not think about them as law. Morals, ethics, manners, we don't think of those things as law. But if you look at Sharia, the books that are articulating what we would call law, like property law, family law, they're in the same books that are talking about how to treat your parents and how to pray and what kind of charity you should give and all the kind of things that we would call not law. So the categories don't fit, first of all, but we filter the topic through the perspective of a Western mind where law is all with the state. So if you say you want Sharia and a Muslim says, yes, of course, then you think, oh my God, you want Sharia law, and that must mean the state law. So to get you a little bit more of this, I want to just explain, this is huge summary of a lot of history and a lot of literature, but this is in a nutshell. If you look at Muslim lands, before colonialism I'm talking about, if you look at Muslim lands, there were actually two kinds of law. For a, quote, Islamic-run state or a Sharia-based state, there were two types of law that was happening. One was this green circle over here, which is what the ruler was doing. The ruler was making rules that ran the society. And it was things like marketplace weights and measures and building roads and raising armies and things like that. The basis for the ruler's lawmaking was not about scriptural interpretation. The way that the religious scholars, talked about the legitimacy of the state, the legitimacy of the ruler, whether it's a caliph or sultan or king, is that they have an obligation to serve the public good. The Arabic word is maslaha amma, and they spoke in terms of what is the ruler's responsibility to serve the public good. And that is the basis for them telling the population you have to obey what the ruler does. Not about scriptural interpretation. In fact, there was a big fight between the religious scholars and the rulers at a time period in Muslim history very early on, where the scholars resisted the rulers claiming to know what scripture meant. So Muslim history does not have a history of church and state. We don't have a church, first of all. There's no clergy or any entity that speaks for the religion. But even the religious scholars who articulated the religious rules for people, they did not also occupy state power. They were very separated. So this idea that Muslims need to just come along and grow up and have a reformation already and just, separate your church and state. It's a weird kind of comment for me to hear because, for one, it's a little paternalistic. But the other thing is we didn't have that problem, right? We didn't have state churches. We might have had other problems, but not that problem. Anyway, so the separation of these two types of law, let me just drill down. The ruler law is called siyasa, if you're talking about the word that's used to refer to it. The kind of laws that the fiqh scholars were making, I'm just going to give you a little bit more detail because this is also something people don't realize. There is scripture that tells you how to live your life as a Muslim. That's what the fiqh rules are. That's what the religious scholars are making. They're trying to identify from the scripture how should you live your life as a Muslim. I like to say it's like a recipe. So Sharia is like a recipe of how to live on this earth. It's God's recipe for how to live a good life. And you have information about that written down in these two sources, the Quran and then the example of the Prophet Muhammad. And then the thing is that just like with a recipe, you can't taste a recipe. It's a piece of paper. You can only taste what a chef makes out of that recipe. And so what ends up happening is the more people doing the interpretation of that scripture, those scriptures not going to answer every question, right? So you're going to have to do some extrapolation. And extrapolation is this word called ijtihad, which means struggle or effort, doing something really difficult. And the effort that they concluded were the particular rules. So the rules of how to live your life as a Muslim are called fiqh. Now that's very important to look at the Arabic meaning of the word fiqh. It means understanding. It doesn't mean God's law. It means understanding. So the scholars recognized that they were fallible human beings doing this. And so the nature of fiqh itself, the nature of Sharia in the world of rules to live as a Muslim is actually very diverse. It depends on your school of thought, your school of law that you follow to decide whether you have grounds for divorce or whether you can buy this property, et cetera, et cetera, et cetera. So that's the world of fiqh. It's highly diverse. You can pick and choose which one you want to follow. There is no entity declaring that for you. And they lived quite independently of the state. When you move into the modern period, this complicates things for everybody, and it has something to do with this fear that Muslims want to be like Iran or Saudi Arabia, or pick your Muslim country that's quoted in these conversations. And that is this division of fiqh and siyasa, which I can go on about how do they operate an overall legal system with both of these types of laws. It's quite interesting. Constitutionally speaking, it's quite interesting. But that original separation of those two types of law was deleted because they were colonized by European powers. And European powers, whether it's Britain or France or the Dutch, they operated on that mindset of law is all with the state. So they got rid of this divestment of these two kinds of law, and everything is centralized with the state. And when you have modern independence movements in the 20th century, they don't criticize that change. So if you want, some of them said, hey, those colonials, they took our Islam away from us. They took our Sharia away from us. We want it back. Unfortunately, they didn't really look creatively enough back in time, and they ended up legislating fiqh rules to be part of the enacted law of those states. So this is the picture here of when you're looking at Muslim countries overseas, when you say, oh, Saudi Arabia or Iran or Pakistan is doing this, I say, yeah, and it's not what I would do if I'm looking at a fully organized Sharia-based system. It is a merging of colonial rule, European nation-state rule, with a little bit of Muslim clothing thrown on top of it. It's not an inherently Islamic kind of system, but yet our conversation today is so much infected by pointing at all the countries that are Muslim-majority lands as some kind of indicator of what Muslims would do here. It's just an indicator of this weird political evolution post-independence of these states. It really doesn't say anything about what Muslims personally would want to do. So the last slide then is this point. So when a Muslim says, I want Sharia for me, what they're talking about is fiqh. They're talking about the personal rules that apply to them to live as a Muslim. The laws that apply to the state, if it were a Muslim state, are a completely different set of laws. And by the way, they're not supposed to be the fiqh rules. They're supposed to be rules about the public good. So for one, there is no, Muslims would not hold a non-Muslim government to be a Muslim land, right? So there's very strong principles in Muslim literature by the religious scholars of if Muslims live in a non-Muslim state, and this has been going on since before Muhammad even established a Muslim rule, that there have been Muslims living as minorities in non-Muslim states, living under Christian king in Abyssinia. The rule that the scholars have said is you follow the law of the land of the place that you live in. So there's a fundamental Sharia obligation that American Muslims have to follow the law of the land that we live in, with one exception, and that is if you are not allowed to do what is mandatory, or if you're made to do what is prohibited. So in other words, if you are made to drink wine, or you're prohibited from praying. Right? So those are two obvious endpoints. And then, interestingly enough, if those situations happen, what's the result? It's not you should overthrow and take over. No, if either of those happen, you should leave. So that's the message to Muslims living in non-Muslim lands. Follow the law of the land unless they're keeping you from doing the absolute mandated and prohibited. And if that's not happening, then you leave. So in the United States, there's a huge difference between what fiqh applies to me. So when these Muslims are going into these family law courts and saying, I want this applied to me, it isn't saying anything about what I want applied to you. It's not about what the state is going to apply to everybody. If I were to hold this state to Muslim values of what the state should do, it would be public good. It would be clean water and green spaces and, regulation of harmful intoxicants in the food, or good zoning codes to make sure our buildings don't fall down. Those are the kinds of things that the siyasa ruler did. But that division, it isn't even in the conversation among Muslims. Muslims have lost their ability to even talk about this because so much of this has been colonized, even in the educational system in Muslim majority countries. So I've diverted just a little bit onto my book topic because that's what I'm trying to do with my Islamic constitutionalism. But I want to end with this. So all of what I've just said is really not about Sharia. It's really about American secularism. It's really about what do we want to do as a country where we're going to be multicultural, multi-religious, multilinguistic, as I said, and what religions are going to be recognized and how, and what will that do to our, fabric of American society. And I think that the voices of Muslims in this conversation is valuable to working that out. Unfortunately, the whole anti-Sharia movement has actually created this fear of Muslims to the point where, in some cases recently, you actually see the argument that Islam is not a religion, not even entitled to First Amendment protection. So if we're working in that direction, I really, really do have a question about what is American secularism if we preserve religious freedom, but we narrow the religions that we mean that for? Like, what is that really doing to us as a community when we really are that diverse? So I hope that we can all think about the bigger picture here, but I'm happy to answer questions about the specifics of the presentation. Thank you so much for the listening. Oh, yes, go ahead. Good.
Well, my background is I worked in Iraq and Afghanistan, working with that one
Yeah.
institutionalism and everything.
Yeah.
So, and places I've been, the real fight is between Muslims and this, if I say Salafists, you'll understand what I'm talking about, others may not, who've declared constitutionalism a religion and therefore try to go that way, you're infidel and you're not allowed to believe. So I'm curious as to how to approach that constitutional question. So I even tell my people who come in and educate the people I work with, which is in place on don't use the word constitution, use the word Sharia that's been written down, and then go through the constitutional things, because it's like a layman can understand the Sharia, which was their prominent one, and that's what your government is draft. Because of Zia using that, I want a Muslim state, and therefore I get political power by explaining to the poor who don't understand the differences. So I'd love to hear your thought pattern on how that constitutional thing is going to.
I'd have to look at more details about really on the ground, like what actually was enacted in those areas, if they actually legislated anything in particular. I've done a review of Afghanistan itself. I actually went to a conference in Afghanistan, and I sort of did a critique of the Constitution based on my sort of perspective. When they say Hanafi Sharia, it's one of the circles, by the way. The Hanafi Sharia, what he's talking about, is just one of those many schools of law. My personal concern when any state picks any school is, and that's exactly what the radical violent groups, and it's not only the violent groups are doing this, but they use this tool of control by picking one and saying we're the only one that's right. And I have a problem with that because the scholars themselves never spoke that way. The scholars, the leaders of these schools always spoke with, it's possible I have this wrong, that's why it's just my understanding. And that's why the schools exist, is because they had to acknowledge it's possible that they're wrong and so the other schools could grow up. So whenever I see any government picking one and enforcing it on everyone, I get nervous because I look at our Muslim history and I say, it's for Islam a matter of religious freedom for me to be able to choose which school I follow. And I think the state should facilitate that choice rather than selecting one that they prefer and enacting it on everyone. I also get nervous if the fiqh of the Hanafi school is being negotiated in the political sphere, because there's all kinds of stuff that happens when you have to negotiate through politics that they never did before, right? The evolution of the schools happened by scholars in universities. It didn't happen in the state. It wasn't legislated. It wasn't happening in the courtroom. If the judge was applying a law from a school, the law it wasn't a common law system where the law came out of the courts. He looked to the law that was written by the scholars in the universities, and then he or she, there were some women judges, would apply that. So what you're describing is a little bit of what I'm talking about, but it's a little bit of what I'm concerned about too. It's like the centralization of one school with an entire land tends to fossilize the law that used to be very evolutionary and organic. Yeah. Yes, in the back.
What is your view on Sharia law as it relates to divorce and custody of children over the age of 6?
So first, I don't like the phrase Sharia law. I told you that already. Because it depends on, so what is my view of fiqh rules about custody of children after, yeah. So the classical, I don't have time to talk about custody. Basically, none of the Islamic custody rules ever get any of the light of day in the United States, because the general rule in all the states is public policy, and there's now a general consensus that the best interest of the child is the public policy. So anything that is more rigid than that is not going to get recognized. The classical Islamic law has a pretty rigid rules about who gets the child based on the age of the child, the gender of the child, and the gender of the parents. So I personally don't like that. I don't think it's demanded by the scripture, but I would want the change of that to happen through more scholarship of the fiqh and say, these are all the reasons this doesn't work, and here's all of the other ways that we could interpret those scripture, and then put it in the marketplace of ideas of the fiqh to have the ones that are more suitable for families be the ones that people go to, right? So in my imagination, if you have a choice of which fiqh school you go to, what happens, and that's actually happened in the past, the schools that don't serve the public's needs very well will die out over time. There actually used to be hundreds of schools. So the ones that we have left are the ones that just, in many ways, were the most used. So if it's not serving the public's needs, it's not going to survive. So I would like, instead of censoring out certain schools or stopping them or banning them through the legislation, that often just gets people very defensive about, hey, it's in my classical scholarship, you're telling me this is, they get very religiously defensive. So rather than try to shut it out, I would just rather have Muslim countries create ways to create alternatives and then have the public be able to go to those alternatives, and then eventually have the ones that were not useful for a modern era die out over time. They also happen to be very relevant to the time. When it's a very tribal society, very patriarchal society, maybe those gendered rules might have made more sense. So that would be a factor in the ijtihad that you would look at. Like, what is a new issue that has to be taken into account through your analysis? So let's see if somebody else, yes, go ahead. Yeah, you.
Going back to divorce.
Yes.
Practical level. How do you see the application of consideration and knowledge? So you go into a marriage, and your husband is a student, and now he's a neurologist, and you've been raising your children, and you agreed to $10,000.
As your mahar, yeah. So what would be the divorce settlement? So again, if you're looking at the existing fiqh schools, and actually some places that are doing some reform work on this, possibly she's got money that she's invested that's her own. That's quite possible. So her assets might not be just in the marital assets. She might have some of her own. She might have her own income, but if she's been at home, maybe she doesn't. That's one of the reasons often women are like, I don't want a mahar, it feels like I'm selling myself. And I say, well, if you want to stay at home, you might want something to invest and get, $20,000, $50,000 and invest it so that you can have financial independence even if you're staying home and not having a job outside the home. But if she doesn't have anything, then you would look to see if there's any other way of arranging for a fair compensation of the financial disparity if they were to leave. Now, part of this would be the type of divorce that would happen, right? So if it's a talaq, she probably have a lot more power in that negotiation with coming back to a judge and saying, wait, I got left with nothing. I would like a divorce where I have something. The other thing that I've wanted to say is that in some scholarship, and I've read in Iran, I need to look into this more, there has been some looking into classical scholarship on the fact that the scholars had said in the past, so not only is a woman's property her own property, but there's also no obligation as far as Islam is concerned, the scripture is concerned, to do housework. So in fact, the scholarship would say that if she comes from a place where she's not used to doing housework, the husband either does it himself or hires someone to do it for her. That's the classical, this is like, 1,400 years ago, people talking about, 1,200 years ago talking about this. So from that, some of the modern scholars, I've been told, actually in the courtrooms in Iran, have said, based on that, if she was doing all the household work and she was not compensated for it, you can add up all of that value and she would get that as part of the financial settlement. So I like that idea. I think that's a way to address, without throwing in community property into the situation, of that particular situation where she's worked at home, right?
Yeah, I'm talking about in the United States.
In the United States, how is
The application of this contract.
Yeah. They use the dissolution of assets almost never gets decided. It's over whether the mahr is part of the dissolution of assets or not. If it's a community property state, it's straight up community property. Right, exactly. Yeah, I'm sorry, I misunderstood the question. Yeah, I mean, if it's not a community property state, then they would look to see what's the laws of financial distribution that they would have under divorce law in general, and we have experts here who can tell you more about that. But yeah, the mahr is usually an additional piece to an existing financial dissolution. Thank you. Great audience. Thank you.